they went to the Supreme Court, and this is where we start. Now, there's been another very famous UK case about how to classify foreign entities, and the case is actually just a couple of years before, and it was called MEMEC. And the Supreme Court looks at the precedents of MEMEC, and it says, well, MEMEC is not applicable here because MEMEC is different, right? And here they discuss the differences, and the Supreme Court says, further arguments were advanced by both parties on the basis of the MEMEC case, and then it explains what MEMEC was. The taxpayer MEMEC PLC was a partner in a German silent partnership. The partnership had no separate legal entity, but was a contractual arrangement, just like the LLC, right? But the LLC had a separate legal entity, personality. The other partner, MEMEC GmbH, was a German company wholly owned by PLC. So PLC basically owned the whole of MEMEC, right? It alone carried on the business of a silent partnership. It alone owned the assets of the business and the income of those assets. It had wholly owned subsidiaries. The subsidiary paid dividends to the GmbH, to MEMEC GmbH as a managing partner. The question was whether PLC could claim credit under the double tax agreement for German taxes paid by the subsidiary of the GmbH on their trading profits. So as far as the corporate income tax was concerned by the German subsidiaries, which then they paid, and then they take the rest and pay that as dividend to the GmbH, which the GmbH then transferred to MEMEC. The question was, can MEMEC get a credit for those underlying indirect taxes, right? And the first point was whether the dividends paid by the trading subsidiaries to GmbH should be treated as having been paid to PLC. It was considered by the commissioners that if that premise were established, the relief would then be due. Okay, but it was then said what was being sought was relief in respect of underlying tax on the profits out of which the dividends were paid, right? So it's an indirect tax. Such relief was only available under the equivalent of Article 23(2)(b, and remember we're looking at Article 23(2)(a). The critical issue was whether the dividends were paid by the subsidiaries to PLC for the purpose of the treaty, notwithstanding that the payments were made to the GmbH. And then, in deciding that relief was not available on this basis, Robert Walker J., the judge, considered that the decisive point was the absence of any proprietary right enjoyed by PLC in the shares of the trading subsidiary. So again, the judge was looking for a right in rem, right? The shares and dividends belong to GmbH. Its contractual right to a share of profits of the partnership must be regarded as a separate source of income, and therefore PLC was not entitled to the dividends from the trading subsidiary. But the judge then goes on and says, now if we look at Anson, the present case is not concerned with the relief under Article 23(2)(b. If it were, if, for instance, the taxpayer were Anson PLC, a UK resident company, then it would be necessary, as in MEMEC, to consider whether Anson PLC could be treated as having been paid the dividends received by LLC from its subsidiaries, but this was not the case. The issue in this case is whether the income on which Mr. Anson paid tax in the US is the same income on which he is liable to tax in the UK. The issue is different from the issue considered in MEMEC, and therefore he doesn't look further at MEMEC. But I find this, this is very narrow splitting, right? You have a partnership, it is transparent in the US, LLC is transparent in the US, you tax in the US on the LLC income, and now the question is whether that income is the same as the income that you are receiving in the UK, and all because the question is, well, should the LLC decide to do some of the profits, or do the profits belong to you already, right? And then the court starts with, actually the court starts very interestingly with looking at Article 23 back in 1940s under the first old US-UK treaty. And it goes through UK law history, and it talks about when you had franked income and where when in the UK law you actually got a credit for the underlying company tax, and it says you have to read the old treaties in that light, and then the UK law changed, and the way the current treaty reads must considering the fact that there was franked income in the old days before you can just decide that Mr. Anson is entitled to a credit. I think this is digging really deep into the history of the treaty and ignores the Vienna Convention on saying you just need to start with the ordinary meaning of the text and the purpose of the treaty, but the judge does end up there, right? Because the next thing he does is he says, relief under the convention in the present case. Mr. Anson maintains that the income arises as profits earned by the LLC, regardless of whether they are distributed. And that's also the way he's being taxed, right? The income which is liable in the sense that Mr. Anson pays tax whether the LLC has made the distribution or not. The income which is liable to tax is therefore Mr. Anson's share of the profits. The commissioners argue that that income arises only as and when the profits are distributed. If no distributions are made, then on the commissioner's argument, no tax liability arises. And that's true maybe under US law, but not under, that's maybe true under UK law, but it's not true under US law, right? The commissioner distinguished partnerships from the present case on the basis that the business of partnership is carried on by the partners themselves. And in this case, we saw clearly that the LLC carries on the business, even though it is the partner, the members that work in the case, right? In the case of a partnership, the source of the taxpayer's income is the business carried on by the firm, whereas in the present case, it is said the source of Mr. Anson's income is his right under the LLC agreement. That's what the commissioners argued, right? The premise of the commissioner's submission is that because the business of the LLC is carried on by the LLC, it necessarily follows that the profits generated by the business belong to the LLC, which is not a illogical argument. On that premise, the effect of the LLC agreement must be to require the LLC to transfer its profits to its members. But now we come back to Mr. Abrams, Mr. Anson's expert witness, which says that's not the way it works, because profits and losses are different from assets and liabilities. And the court follows that argument. The difficulty with this argument, says the Supreme Court, is that it is contradicted by the findings made by the FTT. And remember, the FTT is the one that determines what foreign law says, because it's a matter of fact. And that's for the first court. It's not for the subsequent courts to decide on the facts. It's relevant to note in the first place that the rights of a member of the LLC were found to arise from the LLC Act combined with the LLC agreement. Secondly, that agreement was not a contract between the LLC and its members. The LLC was not a party to it, but was brought into being by it. By signing the LLC agreement, you create, between the members, you create the LLC. It was thus the constitutive document of the LLC, yes. It was against that background that the FTT made findings which contradict the premise that the profits belong to the LLC in the first instance. Their conclusion was that under Delaware law, the members automatically became entitled to their share of the profits generated by the business of the LLC as they arose. The evidence as to Delaware law entitled the FTE to make that finding, right? So the court now says the upper tribunal was wrong, and then they say if then Mr. Anson was entitled to the share of the profits allocated to him rather than receiving a transfer of the profits previously vested in the LLC, it follows that his income arising in the US was his share of the profits. It is therefore the income liable to tax under UK law, and Mr. Anson's liability to UK tax is therefore computed by reference to the same income as was taxed in the US. He accordingly qualifies for relief under Article 23(2)(a), and for these reasons, I agree with the conclusion reached by the First Tier Tribunal and would therefore allow the appeal. And so Mr. Anson finally won the case. Now, this case was decided in 2015. I think an interesting exercise would be to see what about BEPS Action 2 on hybrid entities. Does this change anything? And if you look at neutralizing effects of hybrid mismatch arrangements, I cannot really find anything that would make this different, even though clearly the LLC might be qualified as a hybrid because it's not necessarily a hybrid under UK law. And then there was also the neutralizing effect of branch mismatch arrangements, which was published in 2017. And again, I mean, if people disagree, please let me know in the comments, but I don't see any changes that this document could bring to the Anson decision from 2015. But what is interesting is what Action 2 did with hybrid entities under Article 1 of the 2017 Model Convention, right? And paragraph 2 says, and let's install the words Anson and LLC here. For purpose of the US-UK Convention, income derived by or through the LLC that is treated as wholly fiscally transparent under the laws of the US shall be considered to be income of the LLC, but only to the extent that the income is treated for purposes of the taxation by the US as income of the US. And the LLC was not taxed in the US, right? So therefore you cannot say that it was treated as income of the LLC under the treaty, under Article 1. Whether that means that you should then argue that therefore must be income of Mr. Anson, I would argue, well, who else's income it could be, and in that case, in that way, the Article 1 maybe does change the outcome a little bit, but still, it was not necessarily winning the argument for Mr. Anson, right? Because the argument wasn't whether it was his income; it was whether the income that was his income was the same income as the income that he paid tax on in the UK, and it's really splitting hairs very finely. But I think the UK courts tend to be very, very good at that. I'm not saying it's not real. I'm just saying they're very, very good at it. I hope you enjoyed this case. I thought it was interesting. It is quoted a lot in English literature. And now you know a little bit about it more. I look forward to the next case we discuss together. Bye for now.